Hi guys, welcome to my channel, The Legal Affair with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on marriage and the various types of marriages that you can conclude in South Africa. Please, of course, do remember to subscribe to our channel on YouTube, The Legal Affair. You can also follow us on social media, The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. That's at attorney_bay. So, in South African space or South African context, there are various types of marriages that parties can conclude. Now, one such marriage is, of course, a civil union. Civil unions are regulated by the Civil Union Act, and one of the goals or the purposes, or purpose rather, or intention that the Civil Union Act was brought into existence is to enable parties that are the same sex to enter into a civil union. Now, there isn't a limitation according to the Civil Union Act on same-sex marriages. So the Civil Union Act is not only for parties that are the same sex, rather parties of the opposite sex can also enter into a civil union. The second type of marriage that's recognized in South Africa is a marriage according to or religious marriage. So a religious marriage is a marriage that is concluded in accordance with a religious practice. So for instance, a marriage concluded in accordance with Hindu practices, or a marriage that is concluded in accordance with a Islamic practice. So what we do also know about religious marriages is that religious marriages are marriages that are automatically in community of property unless the spouses to a religious marriage conclude an antenuptial contract. Now, the third type of marriage that's recognized in South African space is a customary marriage. So, a customary marriage is a marriage that is concluded. For one, we know it's a marriage in community of property, but it's also a marriage that is concluded or brought into existence upon the conclusion of a customary practice. So, we do know that when it comes to customary marriages, for instance, with lobola or mahari negotiations, upon the completion of the lobola or mahari negotiations, we have a customary marriage that comes into existence. We do know, of course, when it comes to customary marriages, rather, as mentioned, customary marriages are marriages that are automatically in community of property unless the spouses in the customary marriage conclude an antenuptial contract. And the last type of marriage that's recognized in South Africa, perhaps the most common type of marriage, is a civil marriage. Now, civil marriages are also classified into two. They're broken up. We have, number one, a marriage that is in community of property, and we have a marriage that is out of community of property. Now, with a marriage that is a marriage in community of property, it means the spouses or the parties in that particular marriage have half share or are entitled to a half share of that other spouse. Essentially, what a marriage in community of property is, it enables the other party to own or have access to 50% of your assets, and equally also, of course, your spouse will have 50% of your assets. What is important to understand when it comes to marriages in community of property is also that spouses in marriages in community of property are also liable for the liabilities of the other spouse. So not only do you share your assets, but you do also share liabilities if you are married in community of property. Now, what we see with a marriage out of community of property is also another classification. So with the marriage out of community of property, we have a marriage system with the accrual and without the accrual. So you have a marriage out of community of property where the accrual system is applicable, and a marriage out of community of property where the accrual system is not applicable. So if you are married out of community of property without the accrual system being applicable, it essentially means you and your spouse are separate. Whatever belongs to you is yours alone, and your spouse is not entitled to it, nor are you liable for whatever liabilities your spouse may have. Now, when it comes to a marriage out of community of property with the accrual system essentially enables the parties or the spouses to the particular marriage to share whatever assets accrue or accumulate during the subsistence rather of their marriage. So what we see with the accrual system is that when parties enter into a marriage out of community of property with the accrual system, everything that they had owned prior to the marriage can be separated and regarded or classified as belonging to them, and then whatever they own from the commencement of the marriage and what accrues to them during the subsistence of the marriage can actually be shared with the other spouse. We do know, of course, that there are certain exclusions that are applicable when it comes to what is classified as that which accrued to a spouse. So for instance, if your spouse donated an item to you, or if you inherited certain assets, those can be separated from what is regarded or deemed to have been to have rather accrued to you. So when it comes to marriages, really, I think it's quite an important conversation for prospective spouses to have. Which marriage system do they think is best? I don't necessarily think there is a right or wrong marriage system, really, but I do think it's quite important for you and your spouse to have the conversation, specifically to understand what differentiates a marriage, like a religious marriage, from a customary marriage, from a civil marriage to a civil union, and of course understanding what the consequences are. And as mentioned, we do know that when it comes to marriages that are customary marriages, or marriage concluded in accordance with customary practices, when it comes to religious marriages, and when it comes to civil unions, all three of these marriages are marriages that are automatically in community of property, unless the unless the spouses, rather, to that specific marriage enter into an antenuptial contract. And the purpose, or one of the purposes, of course, of an antenuptial contract is to enable the spouse to separate what belongs to each spouse. So like I mentioned, I don't think there's a right or wrong marriage system, but I do think it's an important conversation for spouses to have on marriages. Now, another uncommon conversation, but one we're having today, is can you actually change your marriage system? So if you're, for instance, married in community of property, can you change your marriage system and make it a marriage out of community of property? So then the answer is yes, you are allowed or enabled legally, that is, to change your marriage system or your matrimonial regime. In other words, you can move from being married out of community of property to being in community of property, and vice versa. So you do, of course, require the services of an attorney. They will they will have an application that is done on your behalf, and that application will be launched in the High Court, and it will enable you to change your marriage system. So from today's conversation, we hope you finally understand the differences between the various types of marriages. And once again, thank you for tuning in.